Changes to visitation for parents when it comes to their children is coming right here to the state of Oklahoma after a recent court case. So what does this mean for you and your situation? Here with me now to break this down is Joe Dorman, the CEO of the Oklahoma Institute for Child Advocacy. Joe, welcome to the show.
Good morning.
So in a recent decision here, the Oklahoma Civil Court of Appeals held that parents can now seek a change to the physical custody schedule. I want you to break down this change for us and kind of explain what happened here.
So for years, the court in Oklahoma has held a very high standard when it comes to determining the visitation schedule. And once that has been ruled upon, it's been very hard for a parent going forward to change that visitation schedule. OICA works quite a bit in the area of adverse childhood experiences. That's 10 different factors that we look at on determining childhood trauma and how that could impact children as they become adults. One of those factors is separation from a parent, be it incarceration, death, or a separation like this. The social science says it's best for both parents to be heavily involved in the life of the children. And so this court ruling will go a long ways into applying the social sciences and making sure these kids have access to both parents.
And you mentioned that court ruling there. I mean, it really was a particular court case that kind of brought this to the forefront there. Can you tell us a little bit about that case and how it prompted this change?
Absolutely. The case is Swaney versus Villanueva, and one of the parents had moved out of state, and they tried to adjust, or that one parent tried to adjust the visitation schedule and had met some reluctance. And so it was taken to court, and the judge in the case ruled that the child should have that opportunity for visitation. Essentially, Oklahoma's had a very high standard, and this court case lowered the bar to make it easier for both parents to have access to the child. And we hope in certain, most situations that it will be equal access. Of course, the one preeminent factor will be the safety of the child. If a parent is determined to not be fit, that will be weighed into the visitation and that custody. But if there are no issues with harm to the child, we certainly want to see equal opportunity for both parents to have access to the children.
You kind of just answered my question there. I mean, I was going to ask, for parents who may be concerned if they're the main caregiver, they're concerned about safety of their child with the other parent in the picture here. I mean, just maybe reassure what's going to be done to make sure that you're not potentially endangering that child.
You're going to have several officers of the court, DHS, other factors who will be involved in the welfare of the children, and guardian ad litem. They will be involved to make sure that the children are safe and that issues that could possibly weigh into the safety of the child are investigated. This going forward will make a big change as far as adjusting visitation. And so I expect we'll probably see more challenges in the court with family members going to apply for either equal visitation rights or at least an adjusted visitation. And by this ruling, it's going to make it easier for parents to have greater access to their children.
So this is not just a blanket, anyone who wants to adjust their visitation can. There's going to be an appeals process, and a judge to rule on that, correct?
Absolutely. Every situation, you're going to have to go before someone and show that you're a fit parent and that you can provide this. It's just the bar is going to be lowered to allow that change and make it easier, and certainly easier up front, to ensure the kids have equal access to both parents.
And I know you all there at the Institute have come out and said that you are in support of this ruling. Why do you feel that this ruling is good for our children?
When it comes to children, they need both parents in their lives. And if there is a divorce, if we certainly understand families will have problems and there may be a need for separation, there may be a need for divorce, but the children shouldn't be dragged into those cases. And all too often, the children are leveraged in these cases when it's simply bickering and a disagreement between the mother and the father. And so we want that taken out. We want to make sure that the children are held harmless in this. Let the parents work out their differences, but don't punish the children.
If people have questions, maybe this is sparking an idea of something that they maybe want to adjust in their situation, what would be the first step that they should do?
Certainly, I would, if they're involved in a case right now, I would ask them to talk to their attorneys and consult the case with Swaney versus Villanueva and look at the factors that were involved there, and certainly reach out and look at seeking the adjustment for the visitation schedule. And if they have any questions about that, certainly they can contact us at OICA, and we'll be happy to try and point them in the right direction.
Okay, Joe, thank you so much. The CEO of the Oklahoma Institute for Child Advocacy. As always, thanks so much for coming on and breaking this down for us. We appreciate it.